I was in court one day, and now closing arguments were about to begin in this medical malpractice case. The defense lawyer stood up and now gave closing arguments first. That's what happens in New York. The defense lawyer goes first, and then the plaintiff's attorney. He turns to the jury and he says, "Ladies and gentlemen, what good will this money do this injured patient?" You want to know what I thought about that argument? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. My mind was on fire when I heard this argument. What good will the money do? Therefore, you should not give this patient money. You should not give him a dime, is what he was arguing to this jury. What good will it do? He's severely injured. This injury happened not because of anything my client, the doctor, did. Therefore, there should be absolutely no reason you should be giving this injured patient a single penny. We feel terrible that he underwent such horrible injuries, that he had to undergo this terrible rehabilitation, that he's now significantly disabled. We feel very bad. But the defense attorney turns to the jury and says, "What good will this money do him?" When I heard that, I was so upset. I was so angry. And why was I so angry? I was so upset because this type of argument is sometimes made by a defense attorney to try and show to a jury that this patient is so horribly injured as a result not of something his client did, but something totally unrelated. And anyway, even if his client did something, these injuries are not worth what the plaintiff, the injured patient, claims they are. What good is the money going to do? I'll tell you what good the money's going to do. In our civil system of justice, money is the only thing an injured patient can try and obtain. That's it. We can't go back in time. We can't put Humpty Dumpty back together again, and I guarantee you the patient's doctors will certainly have tried. In this scenario, in this particular case, this patient had horrible lifelong injuries and disabilities. His life was shattered. It was only a fraction of what it was before. He was now limited from doing every type of activity possible. He couldn't comprehend what was happening around him. He needed 24-hour care. He had horrible lifelong injuries, and now his family was going to suffer along with him for the rest of his life. And now this defense attorney had the temerity to turn around and to make the argument, what good is the money going to do him? It's as if he's hitting the jackpot if you give him any money whatsoever. Jackpot? Really? You think this patient wanted to get injured? You think this patient went into the hospital and said, "Hey doc, do me a favor, screw me up big time so that I can go ahead and bring a lawsuit and hit the jackpot and win millions and millions of dollars"? Do you think that ever went through any injured patient's mind? Absolutely not. I've been doing this now almost 36 years and can tell you that has never happened. I have never seen that. So our civil system of justice only says, listen, you can't put patients back the way they were before. We can't turn back the hands of time. And we can't get retribution and seek vengeance against the person who caused you harm and injury. So the only thing our system of justice allows is to obtain money as full and fair compensation for all of the harms and losses and damages that you, the injured patient, suffered because of this carelessness. That's it. There is nothing else that can be obtained. So now when I heard this defense lawyer say, what good will the money do him? He's basically saying, look, even if we caused him harm, okay, we understand that maybe he should receive some money, but what good will it do? He can't travel. He can't go places with his family. He can't get in a car and drive. He can't do the types of activities he did before. He can't work. So what good is it going to do him? Would you like to know what good it will do him? It will make his life a little bit easier. It will help provide for his family. It will help put food on the table. It will help him pay his rent or his mortgage payments. It will help put his kids through school and college. All of these things will help ease the burden that this patient now experiences because they are no longer able to do the types of things they did before as a result of this person's carelessness. You know, there's an old biblical saying that when someone causes harm to another, that person now incurs a debt to that injured person. And the same thing applies in modern times today. When someone has been careless and causes harm and injury to another person, that person literally incurs a debt, not a debt of gratitude, but a financial debt to this person. And the only way to fulfill that debt is to get them to compensate this injured patient for all of the harms and damages that they've incurred. And whether that means they are now injured and damaged for life, yes, the compensation should reflect the extent of their injuries. And now, ultimately, it will be up to a jury to make that determination as to how much this patient should receive as full and fair compensation. When I heard this defense attorney turn around to the jury and say, "What good will the money do him?" I was ready to shout out, "I'll tell you what good it'll do. It'll help ease his family's burden. It'll help ease his burden. It'll give him and his family some peace of mind knowing that despite the fact that he is now severely and permanently disabled and unable to do his daily activities and unable to provide for his family, now they will have some semblance of money so that they can get through their daily lives, so that they don't have to sit and wonder where their next dollar is coming from." All because our civil system of justice requires that the wrongdoer who incurred that debt because of their carelessness now repay that debt in a financial matter to the injured patient. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.